We are standing outside of the Bainbridge Island Municipal Court, where free speech continues to be a hotly debated and tumultuous discussion in our community. Before we turn to this oral argument in the two protection order cases, Jewels v. Houston Wade and William Nelson v. Houston Wade, we need to first look at our island's more recent history with free speech litigation. After neighborhood liar and propagandist, Clarence Moriwaki, secured a permanent protection order against neighbor Richard Renierson, because he did not like Renierson's civil criticisms of him made to the public on social media, Renierson appealed the decision to the Kitsap County Superior Court. Judge Kevin D. Hull of the Superior Court vacated the protection order on the ground that Renierson's speech was protected by the First Amendment. Additionally, Renierson sued the state of Washington in federal court, supported by the ACLU of Washington and the Electronic Frontier Foundation of San Francisco, claiming that our state's cyberstalking law is a violation of the First Amendment as it punishes speech to the public made with the intent to embarrass, harass, torment or intimidate. In the view of Renierson, the ACLU, and the EFF, it is a violation of our First Amendment to criminalize speech to the public due to its intent. That suit was recently revived by the Ninth Circuit Court of Appeals and is currently being heard at the Federal District Court. Months later, Houston Wade, the vocal friend of Clarence Moriwaki, who vocally advocated in social media for Richard Renierson being put in jail for his speech made on Facebook, created his own Facebook page dubbed the Bainbridge Island Bad List and posted photos and commentary and allegations against several neighbors. Two of those neighbors, John Jewels and Bill Nelson, sought protection orders against Houston Wade at the municipal court. Of note, Richard Renierson filed an amicus brief in support of Houston Wade's free speech rights to share his truthful opinions with the public, so long as his opinions were not defamatory. This is noteworthy because Renierson has frequently claimed that Houston Wade has defamed him and has repeatedly asked Houston Wade to remove and correct false allegations. With this background in mind, we will now play selected clips of the preliminary court audio where John Jewels and Bill Nelson secured temporary protection orders against Houston Wade before Judge Catherine Carruthers, along with our added comments. For the full audio of the preliminary court proceedings, please visit our Twitter page.
But I saw somewhere in your narrative reference to a Superior Court action in a hearing yesterday, so I'd like to know about that.
I elected not to file the action and bring a hearing yesterday because I wanted the availability of witnesses, Bill Nelson and Paul Cullen, and possibly other witnesses, as well as an expedited hearing here because of the emergent nature behind the need for an emergency order.
Readers may be aware that Houston Wade claimed that John Jewels had also sued him for defamation in addition to bringing a protection order action. The role of defamation as an unprotected category of speech will be important in this discussion. It would appear, however, that Jewels chose to drop that defamation action when bringing the protection order suit. Apparently Jewels lost to Houston Wade in the final protection order hearing, and Houston Wade has resumed his allegations against Jewels online. The next clip has no import to the free speech discussion, but piqued our interest after Marisa Castaneda and an anonymous Twitter account posted screenshots that appear to be of an email sent by Richard Renierson to John Jewels about a potential defamation suit against Houston Wade. In this clip, Jewels tells the judge that a third party contacted him seeking representation for a defamation suit against Houston Wade, but that he considered their correspondence protected by attorney-client privilege. We have to then wonder if that third party is Renierson, and if so, how did Marisa Castaneda get a copy of attorney-client privileged content? If readers have any further information on this, please drop us an email.
I would soon learn that he's either romantically involved with my soon-to-be ex-wife or just very close friends with her, and presumably desiring to champion her interests. I elected to do to me what he did to Mr. Nelson and others. I was contacted by a party whom I can't name, who found out about the dispute and told me that Houston Wade had done the same thing to this third party, and asked if I would represent them, and I said I probably can't because I have my own dispute with Mr. Wade. I said, may I advise the court that you've contacted me? And he said, no, I consider this to be protected by the attorney-client privilege, so please keep my identity confidential.
So let me go back to this.
Now back to the free speech issues. In this clip we see that Jewels is not only concerned with the speech to the public, but is also concerned with Houston sharing an opinion at all.
Okay, so
Those are
he
the
has
two
a
pages.
personal page where he publishes this, and that's public. And then he has this bad list page, which is also public?
Yes.
Okay.
And even if it were not public, he has exhibited a personal policy of befriending as many Facebook friends as possible in order to command a large audience. It includes thousands of people, including hundreds and hundreds, if not thousands, of my own peers, clients, professional colleagues, the parents of my children's schoolmates.
So he's
Jewels continues to tell the judge that Houston also tags him in posts that end up on his own Facebook wall for others to see and suggests that he has no power to stop this.
So he's actively friending a whole bunch of people to
Correct.
get them on this page.
Additionally,
on both pages.
he further disseminates the information by tagging my name in
By
his
doing what?
posts. There's a functionality usable on Facebook called tagging.
Okay.
And he tags my posts, which causes them to appear on my own Facebook feed. So without my power, all of a sudden, my thousands of friends and clients and colleagues who have nothing to do with Bainbridge Island have it appear.
This claim is false as Facebook provides a great many tools to prevent this. A Facebook user can in fact make it so that posts from friends through tagging do not show up on your personal wall without your approval. Additionally, a user can unfriend those they do not want to post on their wall if they have their wall set to friends only, as Jewels tells the judge his is set. Finally, a Facebook user can block people so they can have no digital interaction with them at all. This is an important detail, because Jewels appears to suggest to the court that Houston has in some way invaded his privacy with one-to-one contact, which if true would potentially further a claim of unprotected speech. Unfortunately for Jewels, his claim about not having power to stop tagging is incorrect. Similarly, Jewels brings up private messages from Houston Wade. This suggests that Jewels is not concerned with Wade's speech to him, but rather he is specifically concerned with Houston Wade's speech to third parties and to the public. This is an important detail, because our speech to the public is more protected, while speech made to us personally might not be protected, so long as we tell the person to stop speaking to us. While we may be able to tell a person to stop speaking to us, we cannot tell them to stop speaking about us. We will see later that Jewels is only concerned with speech made about him to others rather than to speech made to him.
At the bottom of his post, he says, "I am going to ruin you, and it's going to be so much fun."
So this is off of,
A private message he sent me on Facebook.
he sent you this on Facebook on private, through Messenger, is that right?
Correct, Your Honor.
While the judge finds that Jewels satisfies demonstrating Houston Wade's intent, she then turns to the First Amendment issues. Not surprisingly, they discuss Morawaki v. Rynearson and Rynearson's federal suit that argues that intent does not make speech unprotected.
Well, I think you've satisfied the court that what he's doing is clearly intentional, and that he is directing it specifically at you. Based on your petition, it's clear that this would be extremely distressing and also detrimental to you. Now let's go to the First Amendment argument, because
Yes,
that's
Your
the
Honor.
one that is a significant concern to the court. And also you referenced the Rynearson case, and do you have the final status of the Rynearson?
I thought Your Honor might want to see that,
Okay.
and I brought it here.
Great.
I want to embrace the First Amendment issue. May I approach?
Is this the Superior Court decision, or is it
It is the Superior Court appeal for
Okay.
aid of Your Honor. The procedural posture of that case was as follows. Morawaki brought a temporary petition here.
right?
For reasons unknown to me, that was followed by a permanent petition hearing here, which is procedurally unusual to me because I thought those generally go to the Superior Court, but apparently not. The Superior Court the Municipal Court granted the permanent petition. It was then appealed to the Superior Court, and I believe in July of this year, the Superior Court vacated the Rynearson order
Right.
on First Amendment grounds. Now,
Right.
the companion litigation by Judge that was before Judge Layton and eventually the Ninth Circuit was essentially an action for an injunction brought under federal statutes, including 1983 of the Civil Rights Act.
And it was Rainierson who brought that, correct?
And it was Rainierson that brought that action. His case was dismissed by Judge Layton, who wrote in the fall of 2017 that he did not want to rule on it based on abstention grounds because it would constitute essentially an intervention into a criminal proceeding at the state court level under the Younger abstention doctrine. Pardon me.
Into a criminal case.
Here Jew was incorrectly states that Moriwaki was a party to Ranierson's federal suit.
It was a criminal case?
Yeah, well, the argument before Judge Layton presented by Moriwaki.
Moriwaki was not a party to that suit, which was a key fact in the Younger abstention discussion. While Moriwaki was mentioned in court filings due to the protection order, Clarence Moriwaki was not a party in the suit and made no argument despite the incorrect assertion from Jew was.
It was a criminal case?
Yeah, well, the argument before Judge Layton presented by Moriwaki was that because a restraining order could lead to criminal implications at the state court level, it constituted a criminal action at the state court level, and under those circumstances, the Younger abstention doctrine provides that the federal court should not intervene because it's a local matter. The Ninth Circuit Court of Appeals analyzed the 5 Younger abstention doctrine factors and reversed Judge Layton. The matter is now back before him.
In this next section, Jew was completely mischaracterizes the opinion of Judge Layton of the District Court.
It is worth noting, because I find it highly persuasive, that Judge Layton also, in his district court order, not since the remand, but in his original order, said, and I find that in any event, even if I were to reach the merits of Mr. Ranierson's entitlement to a preliminary injunction, I would deny it based on the merits, because it would allow conduct that Judge Layton referred to as bizarre, and frankly, on its face, appears to constitute cyberstalking under Washington's statutory definition.
Jew was tells the judge that he finds his wholly fabricated rendition of the judge's opinion to be highly persuasive, but the actual court opinion is nothing like Jew was describes it. Judge Layton never stated that, quote unquote, and I find that in any event, even if I were to reach the merits of Mr. Ranierson's entitlement to a preliminary injunction, I would deny it based on the merits, because it would allow conduct that Judge B. Layton referred to as bizarre and frankly, on its face appears to constitute cyberstalking under Washington's statutory definition.
If I may provide some clarification for a moment. Contrary to Mr. Dew's completely inaccurate telling of the district court opinion, Judge Layton stated quite the opposite. Judge Layton concluded his opinion by writing that, quote, Ranierson raises compelling questions as to the breadth and constitutionality of certain provisions in the Washington Code. These questions are seemingly reinforced by defendants' reluctance to address the constitutionality of the statute during oral argument. See Docket 31. Nonetheless, Ranierson has already raised these constitutional challenges in his appeal of the civil protection order pending before the Kitsap County Superior Court. Under the Younger abstention doctrine, the court must refrain from adjudicating this lawsuit.
To be fair to Mr. Dewars, Judge Layton's opinion does use the word peculiar to describe the protection order situation and does state, quote, contrary to Ranierson's contention, Moriwaki v. Ranierson is not a run-of-the-mill contract dispute or tort action between private litigants. Rather, it is one party invoking the authority of the local court for protection from the increasingly bizarre conduct of another party. And while Judge Layton did not give any example of anything peculiar or bizarre in the protection order that was knocked down by the state superior court, those are subjective terms. It may be that Judge Layton finds political criticism made to the public to be bizarre, while activists and journalists no doubt would not find such activity to be strange. Likewise, one might find it bizarre that Judge Layton found the Younger abstention doctrine to provide reason to dismiss Ranierson's suit before a law student with only 1 year of legal training, convinced an appeals panel to unanimously find that Judge Layton had wrongly dismissed the suit before sending the case back to him. People can differ on the subjective term, bizarre, but that does not in any way make the characterization provided by Duwas any more accurate. Strangely, after Duwas finds his inaccurate rendition of a court opinion highly persuasive, he then turns to the Kitsap County Superior Court opinion and finds its reasoning knocking down the protection order to, also, be persuasive.
So, the Superior Court judge, to whom the Municipal Court's permanent order was appealed, vacated the order. But the reasoning for it, and this is a good place to begin our First Amendment discussion, the reasoning for it was driven by the First Amendment analysis principles that are contained within the cases I submitted to your honor.
In this clip, Duwas inaccurately names Renierson's lawyer in the Kitsap County appeal to be a lawyer who used to work for him.
In the Milwaukee vacation order, the court vacated the temporary restraining order on the basis that the nature of Mr. Renierson's comments really was political. I've read those posts. Mr. Renierson's attorney is actually used to work for me at my law firm, and First Amendment has always been a passion of my law firm. And so Venkat Balasubramani persuaded the Superior Court, I think appropriately so, that the content of Mr. Renierson's comments didn't do things like call Mr. Milwaukee a drunk or a child abuser or a sex predator or an unethical person. Rather, they used his name and also argued that his political opinions were wrong.
In fact, Renierson's lawyer in the appeal hearing was UCLA law professor Eugene Volokh and the local counsel that had argued the case at the municipal court. This aside, Duwas suggests that Renierson's speech was protected because it was political speech and of public interest. While that is true, the Kitsap County Superior Court opinion was not so limited. Renierson attempted to make this clear in the amicus brief he filed in support of Houston Wade's non-defamatory speech rights.
Contrast that in the Milwaukee vacation order is a lengthy analysis by the Kitsap Superior Court judge talking about how the content of Mr. Renierson's page is, in its substance, designed to discuss political ideas as opposed to doing things that have given rise to culpability and liability under the cyberstalking and anti-harassment statutes in the way of online face postings. So it went against Milwaukee on the appeal to Kitsap Superior Court, but probably for the right reasons.
Here Duwas claims that Renierson called Milwaukee an idiot, a claim that is not supported by the court record, which shows that Renierson's speech was pointed but remained civil.
The judge in the Milwaukee vacation order concluded that it was political commentary, and that was always known. I mean, Renierson never called Milwaukee a drunk or a child molester. He said he's an idiot when it comes to the National Defense of Americans Act because it can lead to unlimited detainment of American citizens. It was a political discussion that Mr. Milwaukee found offensive. I'm a little surprised Mr. Milwaukee got the restraining orders that he did, given that it was on a public issue.
Duwas also misstates the name of the National Defense Authorization Act, but his key thrust is his continued argument that Renierson's speech was protected because it was political speech. While it is true that political speech is more protected, it is inaccurate to suggest that people's speech is only protected if it is political speech. People have free speech rights to talk about many topics that most people think have no value. In the next clip, Duwas correctly mentions a category of unprotected speech that the government can restrain: defamation. It will be interesting to eventually hear the audio from the final court hearing where Houston Wade prevailed and to see why Duwas was unable to convince the court that Houston Wade's claims were defamatory and should therefore be restrained.
One of the types of speech that are exempted from the list of protected speech under the cases interpreting the First Amendment implications of the cyberstalking statute is defamatory speech. And right now, the only evidence before the court is my vociferous, strong assurances to the court that the speech on Mr. Wade's offending pages and the appendant comments is defamatory in nature. It's false. I'm not a sex predator. I didn't commit adultery. I never abused my children. I didn't break my daughter's arm. I've never committed an ethics violation. I have no barred disciplinary record. I'm not a wife abuser.
Duwas then invites a lawyer for Bill Nelson to address the judge in advance of his own protection order hearing. Mr. Cullen correctly brings up defamation as an unprotected category of speech.
I see the analysis the way Mr. DeWars does. This is damaging, false, defamatory information aimed at hurting Mr. Nelson. Nothing else. There's no social benefit to it. And as such, I think it falls within the exception to the protected speech category. The words of the statute, too, refer to, just say speech, it says protected speech. And so that implies that there is the exception. And there are, these are graphic circumstances where the exception is there.
And one thing I would like to do before I make a decision, I'd like to review the Superior Court decision in the Rainierson case. I'm familiar with it. I read it some time ago, but I'd just like to take a look at it since it was a decision. Initially, the protection order was issued out of this court, and then it was appealed and sent and vacated. So I want to clearly understand the grounds in that case. I think it, from what you've told me and what I recall, it is very distinguishable in what happened in that case. And as I recall, it was Mr. Rainierson was not making strictly personal comments. He was making a political argument towards Mr. Moriwaki. And as I recall,
After reviewing the decision in Moriwaki v. Rainierson, the judge correctly determines that the speech in order to be restrained must fall into one of the exceptions, such as defamation, but then incorrectly concludes that Houston Wade emailing the law partners of DeWars is unprotected without any discussion of whether that correspondence included defamatory claims, solely because of the intent of the speech.
well, I had a chance to look at the decision of Judge Hall in Moriwaki versus Rainierson, and look and consider also the case law that you cited in your brief, Mr. DeWars. It does come down to an issue of, is the respondent engaging in protected speech, or do we have someone who's engaging in deliberate harassing tactics that don't serve any legitimate purpose and fall within one of the exceptions? And I think based on my review of the case law, you have established sufficient facts for the court to issue a temporary order to you. There certainly are going to be issues at the full hearing on what portion of some of this might be protected speech. He certainly has a right to his opinions, but when he's in where the court finds that he has gone over the line is in the communications with your law firm. Don't seem to serve any legitimate purpose, and based on his communications to your law firm, that he is intending it to ruin you and to cause you to lose your license. And that's going beyond protected speech, and it's clear that his intent is to cause you harm.
The judge does comment on going too far in limiting speech to unprotected defamatory comments, however, and leaves that issue to the full court hearing for final determination. It would appear that Houston Wade was able to assert his free speech rights and presumably defeat the claims of defamation from Mr. DeWars. We look forward to reading any opinion and reporting on the court proceedings.
Okay, I've looked over the language that you prepared, Mr. DeWars. I think that it is, some of the language potentially goes beyond what would be necessary or appropriate to prevent the defamation. However, it's difficult to tease that out right now under the circumstances, and what I prefer to do is I'll go ahead with this language, but Mr. Wade will have the opportunity to present arguments as to what he thinks of his activities are protected free speech and in what way that he believes that it would be appropriate to communicate his free speech rights.
If any readers can supply us with the court audio or other documentation, please send us an email. During Bill Nelson's preliminary hearing that followed the hearing from DeWars, the judge correctly zeroes in on defamation as unprotected speech and suggests that Houston Wade has made defamatory comments that are known to be false.
Since you were here for the earlier hearing, you're aware that there are free speech issues that are that come into play when someone has a bad opinion about someone. I mean, it is all right generally for people to not like someone and to be able to say that publicly, or to say that they think they're a liar or a cheat or something. It does not allow people to engage in comments that are defamatory, meaning that you can't lie and you can't say something that's not true. What he has said about you here, based on the record that you refer to as far as the court record and your prior court activities involving, I believe, Ms. Caltrider, would indicate that what he's saying about you and regarding her would be defamatory, and because it's not true, and so they would not be protected speech. So based on that and based on what you told me, I am going to issue a temporary order for you.
The final hearing of Bill Nelson v. Houston Wade will be heard on the 13th of this month. Thank you, neighbors, for engaging in our public island processes to better secure constitutional rights in our community. It is only through our active participation that we can make equality under the law a reality, rather than a mere punchline. So thank you, and ciao for now.